Hi, I'm Shan Wu. Welcome to a hot take on Under Color of Law about a controversy that is rather new yet old about the Trump verdict. What's old about it is for a long time you've heard criticism of people saying that this is a novel theory. It's a novel theory of prosecution. It's a novel case. And I said this before, but I'll say it again. It's not a novel theory. It is a novel defendant. That's very different. The controversy that's somewhat new is now that Trump has been convicted, you're beginning to hear some spin about the idea that he wasn't given proper notice of what he's being charged with. So, for example, take a look at this CNN headline. We'll put it up there for you. And it says that the jury verdict was unclear. The jury verdict was not in the least bit unclear. They found him guilty. So it's not unclear at all. But playing on that, some of the commentators are beginning to put this spin on it that there's something that's wrong with the way the verdict was handed down. Take a listen to this discussion with Michael Smerconish and my colleague Ellie Honig.
I want to go into the weeds. Hear from the jury instructions. I'm going to put this up on the screen. I'll read it aloud. In determining whether the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you may consider the following: violations of the Federal Election Campaign Act, otherwise known as FECA, the falsification of other business records, or violation of tax laws. Now I'm putting on the screen one portion of the verdict slip so that people can see it was a binary choice on each of the 34 counts. And here's my question. Based on the verdict slip, Trump can truthfully say he doesn't know for what he was convicted. Do you agree?
I do agree, and I think we all have that issue. Now, that verdict slip that we just looked at is deceptively simple in its layout. It's a binary choice. Guilty, not guilty, yes, no.
Now, the first thing that's really off with this is you have Smerconish saying it's a binary verdict. Yeah, it's a binary verdict, guilty or not guilty. It's always a binary verdict. And then Ellie responds to that saying that the verdict is deceptively simple. Yeah, again, guilty or not guilty. It's a binary choice. It's not deceptively simple. It is simple. What they're both trying to get at, though, is a idea that Trump somehow wasn't given proper notice of what he's being charged with. Smerconish is actually a little bit more clever with this. He says Trump doesn't know what he was found guilty of. And you'll hear that Ellie tries to spin it into he wasn't given the proper notice. Both are wrong, but let's break it down a little bit. I mean, when Smerconish says Trump doesn't know what he was convicted of, obviously he does. He's got a conviction for the falsification of business records with the intent to further another crime. That's what he was found guilty of. But take a listen to how Ellie Honig spins this a little bit in terms of trying to take this idea that Smerconish floated and turn it into a controversy over a lack of notice.
Said, look, a basic fundamental principle of our criminal law process, of our Constitution, is a defendant is entitled to notice in advance of trial with specificity what he's being charged for, what he's being tried for. That's why we have indictments. Now, the indictment in this case does not specify what the underlying quote unquote unlawful means are. And in fact, and I found this to be shocking, frankly, the judge did not make the prosecutors commit to any of those unlawful means until we were just about into closing arguments.
So you have Ellie Honig talking about this violates a fundamental principle that you have to know what you're being charged with. That's what indictments are for. Well, that's utterly wrong here because he was indicted for what he was charged with. He knows what he was on trial for. What he's actually talking about is the unlawful means. So remember that the charge is falsification of business records with the intent to cause some other crime. Within that, you have to have what means by which you accomplished that. And that's what Smerconish and Honig and other people on the right side of things now are trying to turn into a controversy because the unlawful means were not required to be unanimous for the jury. The jury needed to be unanimous on the verdict, but by which means was accomplished, the judge gave them the choices for them to consider. Not really choices. It had to be one of these three. It could have been the means by which they did this crime was the falsification of business records. It could have been tax fraud, or it could be the federal election campaign finance violation. It could be all of them. But the point was, in the verdict form, the jury didn't have to say, we unanimously choose which of these we're relying upon. And that's because the law doesn't require that. It only requires that they're unanimously finding that the defendant committed the crime. Now, I'm not saying that Trump's lawyers can't or won't make the argument that the lack of a unanimity requirement on the means, or a failure even to cite which means in the indictment itself, won't be raised by his Trump lawyers. I mean, they can argue that. You can argue all sorts of things on your appeal. Certainly that last notion that they needed to include the specific means in the indictment, I mean, that's got to be way off in left field. That seems really wrong to me. But, they'll argue that. They may try to really get into the jury instruction to say that it was confusing the way it was worded, or the verdict form was confusing. It's fine. You can argue that on appeal. But what I want to bring your attention to is, as this controversy continues, because now that he's convicted, there isn't too much to do while you're waiting for the appeal besides try to point out that there's something wrong with the way the verdict was done. Keep in mind what Ellie's actual sleight of hand here was, which is he's trying to claim that the lack of specification of the way the crime was committed is the same as not specifying the crime itself. And that's kind of a tricky move on his part. And worse, it's kind of misleading, really, because it's going to lead, it actually is leading, to a lot of commentators and Trump supporters and Trump himself saying that I was on trial, didn't even know what I was charged with. And that's really incorrect. So let me give you some ways of thinking about this. We use the burglary analogy a lot here, so I'm going to try something different. I used to prosecute sex crimes, so I'll use the sexual assault analogy here. In most jurisdictions, if a defendant is charged with first-degree sexual assault, they'll define that first-degree, meaning it's the worst kind, as, for example, in D.C., it's defined as forcing or using some other means to force a person to engage in or submit to a sexual act. How? The means are force, threats, rendering them unconscious. So let's say, hypothetically, the defendant is charged with first-degree sexual assault based on evidence that they threatened force with a knife, they punched, they choked the complainant, also drugged them. That's the means by which they accomplished the crime. And there has to be evidence of that means. Otherwise, they're not going to get a conviction. But the jury doesn't have to agree on which of these means were used, or if only one was used. And the indictment doesn't have to say that either. The indictment can simply say the charge is first-degree sexual abuse. Now, the prosecution is going to have to prove all that, and it's going to come out probably in the opening statement and in the evidence. It's not like the prosecution doesn't have to produce the evidence. That's very different than not giving any notice of the charge. That world would look like the prosecution saying, okay, Ms. or Miss Defendant, you're charged with something, but we're not going to tell you what it is, and you're going on trial for something, but you won't know what it is until the very end of the trial when you get the verdict. That's not what happened here, and I think it's important to keep that in mind as we hear this type of spin, this type of controversy continue to go on. So that's it for now, and I look forward to hearing your comments. Keep them coming because it really helps me to think about what kinds of issues to discuss and how you want them discussed. Thanks, I'll talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.